Morning, my name's Maurice Crespi. I'm the managing partner of Schindler's Attorneys. We're here today as COBRA. I'm joined by Ian Fleming of Engaged Business Turnaround, Gary Barachowitz of Schindler's, Dom of Schindler's, Francois from the IQ Business Group, Paul Michael from Schindler's, Dean Wright from Schindler's, Peter Gordon from Engaged, and Artisha from the IQ Business Group. So we've got quite a few panelists today. The idea today is to deal with questions that you may have, industry-specific questions or questions specific to your company. I mean, if you think about it, if we were to merely pre-record and play, it would be the same as you guys not asking questions. So the reason we're here today with such a large group is to be able to deal with those questions that you may have. If you want to ask a question, you can ask it anonymously. If you feel uncomfortable in asking a question today, please do not hesitate to reach out to us to set up a private Zoom session with you and your team so that we can deal with those specific questions. I'm going to kick off today just by going through business rescue, asking Peter to take us through business rescue in general, and we'll deal with any questions you may have, or we'll deal with certain aspects of business rescue that are important. We call them the take-homes. Importantly, before we jump into business rescue, it's important to emphasize that COBRA is not about business rescue. COBRA is about keeping you out of business rescue and putting you into the ecosystem so that you can turn your business around, a plan can be made without the need to actually resolve that you go into business rescue. But if it comes to it and you have to go into business rescue, Peter, take us through the process.
Maurice, Peter just sent a message saying that his system's frozen. He's going to try and get back in.
Okay.
But let me take you through the process.
Yeah. Thanks.
So business rescue was part of it was introduced by the Companies Act of 2008, which was a much more data-friendly Companies Act than the previous one. The previous one was recognized as being a much more sort of creditor-friendly act. And the aim of business rescue was basically to give companies breathing space, companies that are in distress, to give them breathing space under the supervision of a business rescue practitioner, during which time the company can reorganize its affairs. And by reorganizing its affairs, we're talking about operations, financials, legals, etc., in order to return to a solvent going concern. Now, the solvent going concern stipulation was subsequently relaxed, and allowing companies or business rescue practitioners basically to give creditors a better return than they would get in a liquidation scenario. So yeah, it's designed to be a temporary, business rescue was designed to be a temporary thing, and the Companies Act initially envisaged it being a 3-month period, and that it shouldn't go for longer than 3 months. That has, however, been proved to be very unrealistic, and many business rescues drag on for a year or 2 years or even 3 years in some cases. So we often talk about a steel blanket being wrapped around the company during the time that it's in business rescue, and that's exactly what it is. It's basically to protect the company from legal action that may have occurred before the business rescue started, and to protect the company from legal action during the business rescue process. So yeah, that steel blanket is very important because it allows the business rescue practitioner to really operate without the hassle, or or the inconvenience, if you like, of legal action against the company for the recovery of assets or the recovery of debt, or liquidation. Yeah, in a nutshell, that's what business rescue is. Maurice?
Yeah, great. Thanks for that, Ian. I think at this juncture, what's important is just to deal with the question of the moratorium and agreements. And it's one of those take-homes that we ask that you consider carefully, and that is the moratorium comes into effect the moment the company resolves to go into business rescue and people cannot sue you. However, what the moratorium does not do is it does not suspend contracts. So if you take a lease agreement, that lease agreement will continue to be enforced and still capable of cancellation. So if the business rescue practitioner does not, upon his appointment, send a notice to a particular counterparty to an agreement saying, I'm suspending the agreement, the counterparty to the agreement, so in other words, the landlord, if you're the tenant, can cancel the agreement and can still evict. So bear that in mind, that if you're going to go outside of the COBRA environment, resolve to go into business rescue, you are going to please make sure that the business rescue practitioner is aware of the provision and have a list of all your creditors or all the counterparties to agreements handy with the contact details, so the business rescue practitioner can send those notices immediately. Often it's a race. It's a race between a breach notice and, let's say, the 7 days of breach and sending that notice out. So that's really key. We lost you there, Peter. Are you back?
Yeah, I'm really sorry about that. I think my laptop was still on a long weekend.
No problem. Peter, so you heard me. I just dealt with the moratorium. I think let's take this in stages. So now I've just dealt with the suspension of the contracts. That's quite important, and sending notices to those contracts. But now you arrive. Tell us about your engagement with employees and how that works.
Maurice, look, in terms of, and morning everybody, I'm sorry for the delayed start. In terms of Chapter 6, the employees' rights and obligations are not affected during the business rescue process. So anything that was applicable to employment contracts in vis-a-vis labour law continues in rescue. Employees are part of the process. People tend to forget that they are creditors and they are denoted as affected parties. Employees are creditors because every day they work for you, you're obligated to pay them. So they become creditors by default. But equally, they are protected in so much as one cannot just hire and fire in rescue without taking cognizance of labour law. So any Section 181, 189 reductions in staff, you still have to follow the process. You can fast track the process. The other point of employees is that they have to be advised of the rescue. So I don't know if Ian covered it, but within 10 days of the appointment, the practitioner has to call a meeting of affected parties, being, in this instance, creditors and employees, separate meetings. Normally, the practitioner would ask the employees to choose representatives so that you're not having to communicate with how many of the employees there are. Obviously not applicable in a smaller company. But yeah, they continue. The trick in rescue is that if you do go through a reduction in staff, one's just got to be cognizant of the fact that you may not be able to pay them, because cash is king in a rescue, and you may not have the available resources. And we have had examples, Ian and I, where we've negotiated with the employees to pay out redundancy over a period of time. So it's all about cash flow and how to manage that process.
Well, on that score, another take home is, if a shareholder or the directors of, let's say, a small family business, often they want to lend money to the company to pay those salaries. Peter, do you want to just comment on that? Because I think that's where it becomes important to actually go into business rescue. So maybe you can take us through the notion of post-commencement finance, how that works, and maybe also refer to the ecosystem and what we're doing for distressed businesses.
Sure, Maurice. This is one of the critical milestones of any rescue. You have to have funding in order for the rescue to work, clearly. I mean, if you don't have any available cash, then the business will collapse. So a rescue practitioner will often spend quite a bit of time ascertaining where what we call PCF, post-commencement finance, is going to come from. But one of the important things is, remember that, and I'm sure Ian mentioned it when I was off the system, is that all your liabilities are frozen. So that immediately releases the cash working capital cash that you would have paid to your normal creditors. But if that's insufficient, and as Maurice rightly says, shareholders stroke directors of the small and medium companies are often tempted to put money in to specifically pay employees, but also to pay for other costs, operating costs of the company. Now, the important thing here is that PCF is separate from liabilities that arose pre-rescue. So any PCF creditor is preferred in the rescue. This is a very important point. He's preferred. So a shareholder director who's thinking about funding the company should not do so prior to rescue, because that money then is at risk. And if the company then eventually does go into rescue, it's just treated as a normal creditor and is frozen and can only be repaid in terms of the business rescue plan. There might also, and is often the case, be a compromise included in the business rescue plan. So the shareholder stroke director may not get 100 cents back in the rand. So the trick here is to provide that funding post-rescue, and then is classed as post-rescue funding, is preferred. The rescue practitioner is obligated to pay that before he pays anybody else of creditors that were in existence pre-rescue. And then also importantly, there's nothing to stop a shareholder director asking for security from the rescue practitioner. Remember, he has complete control of the company. That means he has access to any free available value in assets to use as security, and to offer that security up in favor of that funder. And if it is a shareholder or a director, then obviously that person's in a far better position if they were in rescue than if they were not.
Thanks, Peter. Peter, just also, whilst we're on the topic, I mentioned payment loans to pay staff, but a lot of questions have arisen in relation to suretyships and their legal status whilst under rescue. So in other words, what would happen if I signed a surety, the principal debtor being the company in distress, and now the bank wants to go after me as surety? I've got two questions. A, is the surety binding or is it suspended? And B, if not, how should one deal with it?
Maurice, unfortunately, the first answer is no, it is not suspended. In the early days of rescue, the banks had been a little bit slow in including business rescue as a default under their terms of their facilities. That's been rectified in all but a few cases. So a suretyship will apply. That's the banks. Obviously, if that suretyship was offered up to a supplier, for example, or another type of lender, then do have the suretyship agreement checked, because the wording then can become quite important, because there may be a situation where the holder of the suretyship cannot exercise it whilst he's waiting for acknowledgement of his principal and whether the principal's been paid in full or not. But by and large, I think accept that sureties would be valid and the lender can go after the individual at the same time as waiting for whatever funds they're going to get out of the company. Practically, what we tend to do in that is it's a separate negotiation. Obviously, we're concerned about the creditors and the company, and that's what we're trying to rescue. So if somebody has given personal guarantees or suretyships, we do generally, and certainly if that's a director or shareholder of the company, try and work with the shareholder director and the holder of the security to try and find a way of settling that. So, for example, You could have a situation where the suretyship is fairly small, and there is funding of certainly of the director is essential to the continuation of the business. Then we would try and settle with the suretyship. Exactly, it's a practical issue that we will deal with on the day. But yes, we do try and get those suretyships cancelled.
On the question of directors, Ian, we've had issues in the past where directors have felt loath to place their company into business rescue because they will then have a third party independent officer of the court come in and start digging deep. Now, what if SARS has not been paid? How does one deal with those anxieties? Ian, you're on mute.
Maurice, it's very important. Thank you. It's very important for the company to find the correct business rescue practitioner. We always talk about this. Somebody who's going to work with them and cooperate with them and hold their hand through the process to get them out the other side. However, as you noted, as business rescue practitioners, when appointed to a company, we are officers of the court, and the Companies Act specifically states that should we find any irregularities committed by a director, it is incumbent upon us to report that to the relevant authorities. In the case of SARS underpayment or under declaration, the relevant authorities would be SARS in this case. Please note we are not auditors. We're not there to dig and to try to find irregularities. However, it is specifically stated that should we come across irregularities during the course of our work, it is our responsibility to report. How we deal with it in practice is that if we come across an irregularity, or if the director tells us about the irregularity that he is committed to with respect to the under declaration or the underpayment of tax, we would then typically go to SARS and we would say to them, the company's in business rescue, and here's a voluntary disclosure. Essentially, the company has previously underreported earnings to the extent of X, where they should have paid tax of R1 million, for example. They only paid tax of 300,000 rand. It's very important to note now again that SARS is not there to close companies down. One of the main objectives of SARS is to keep companies open and to keep them trading, and SARS is certainly not there to put company directors into jail. Our interaction with SARS has been very positive in the past, where we've come with voluntary disclosures as to the underpayment of tax in the business rescue scenario. And what we would typically do is, under a business rescue, as part of any business rescue plan, typically a company, all creditors get compromised as a result of the plan. In other words, they take a haircut, put it in layman's terms. And we would negotiate with SARS and say to them, listen, the only way this business rescue plan is going to work is if your debt that is owing to you as a result of previous under declarations is reduced from R1 million down to 300,000. That is the only way that the company will be able to carry on trading. SARS has typically worked with us in that regard and allowed us to pass that amendment to the business rescue plan, or for them to be compromised to that extent. So we get to the situation where we only want you to be in a better position as a business owner as a result of us having placed the company into business rescue. So as a result of our negotiations with SARS, you'll typically find a normal situation that you come out much better at the end of the day, even if we end up declaring the underpayment of tax or the under declaration of tax that you've committed in the past. So you come out with not having to pay SARS more than you would have had to pay them in the past, and you come out having declared it and basically being able to start off from a clean sheet.
Yeah, thanks, Ian. So on the score of directors, directors have the same duties. They owe the same duties as they did pre-business rescue to the company. So the fiduciary duties that one finds in section 76 and 77 of the Companies Act remain in play. Peter, can you just tell us from your experience, just dealing with directors and the duties that they owe? Tell me more about those duties, if you can, if you will.
Maurice, yes. Look, our preferred route is always to take a cooperative stance. So we will try and work with the directors. The practitioner can instruct a director to perform whatever task he wants. So he can't remove a director, important point. He has to go to court if he wishes to remove a director, unlike employment, anybody in employment. And of course, as we're aware, directors are both employees and carry Companies Act appointment as a director. So you could make a director redundant in a 189 process, but keep him on, he or she, on the board. Unlikely, I've certainly never had a case like that, but you could do it. If a director is behaving badly, and by badly, and I have had a few, where directors have perpetrated fraud, and as Ian was rightly saying, the practitioner is obligated to investigate, instruct management to rectify and report. And in certainly the one case, both cases in fact were regulated by the FSCA, so I reported to them, and they then began their own investigations of the individuals. But that's an extreme case. In normal situations, as we often say, we know far less about the operations of the business and the nuances of the market and the suppliers, etc., than the directors themselves. So it is pointless going against the directors. The directors' duties, as Maurice, as you rightly say, with some minor relief, are essentially the same as the normal fiduciary duties. An important point here is that the practitioner is also covered by those fiduciary duties. So the practitioner picks up the full fiduciary duties on behalf of the company, must act in the best interest of the company at all times. So with that relationship, you're in the same boat as the directors. So what we find is the directors generally will try and work with us, other than, as I say, if they're trying to do something underhand. Directors are often extremely anxious, specifically the reckless trading clause, section 22 of the Act, are anxious that somebody's going to have a go at them. And remember, we're not there to protect the director, exactly as we're not there to protect people who have signed surety, as I discussed earlier. So we're not there to protect the director. And if the director has, or directors have acted recklessly, then anybody can have a go at them. Unfortunately, in South African law, we don't have many cases of successful claims against directors for reckless trading. I can only think of two after many years of being in business. But one of the essential things with rescue, of course, is if the directors are concerned about reckless trading, then one of the solutions to that is to enter into rescue. And I'm sure Ian covered earlier when I was off the line that, if you've had a discussion about being financially distressed, and don't do anything about it, and that discussion, often bizarrely in the form of director's minute, lands up in the public domain through court cases. That's a very damaging document for a director if a declaration of insolvency was made at a board meeting or even in an email. So be very cautious of that. But if you're in rescue, of course, you cannot be classed as reckless trading unless there's fraudulent trading in a rescue, of course, but I'm not talking about that, I'm just talking reckless. So there is a protection. Directors are protected by going into rescue. But generally, as I say, in summary, we will try and work with the board and the directors. If there's a weakness in the board, remember the practitioner can appoint external assistants. So for example, if you find your finance director is really not up to speed, you can appoint somebody to take on the financial role, not the director role, but the financial role, and essentially hold the finance director in abeyance as regards his specific duties. I think that's about it, Maurice, if I've missed anything.
No, that's great. Just maybe there's a provision in the Companies Act that there would be no recklessness involved. It's an act of God. I think we need to, as COBRA, lobby government just to, or CIPC, to issue a practice note on that, because that would be wholly unfair. So I'll definitely look at that, and we'll consider doing something there. We've dealt with directors and how, in essence, they become servants of the business rescue practitioner. Let me just mention that if there's a business rescue practitioner who is not performing his or her job or is in breach of the fiduciary duties, one can apply to court to have the business rescue practitioner removed. But Ian, what if you don't want to get involved in all of this, but you still want to make a deal with your creditors? COBRA does not only deal with business rescue, it also deals with Section 155 of the Companies Act. Can you just give us some detail there, please?
Yes, certainly, Maurice. Thank you. So it's very important for us to get it right from the beginning, for a turnaround practitioner to get it right from the beginning as to what the course of action is going to be. And we've got various decisions that we can make or that we need to make when we get into the business. So once we've spoken to the directors, once we've as to establish what their view is as to the reasons for distress, once we've analyzed the financial information and tied up the financial information to what the directors have told us, then we need to make a decision. Is it business as usual? Is it an informal turnaround, in other words, outside of business rescue, where we've just informed creditors that the company is in financial distress, but not put it into business rescue? Is it a business rescue? Is it a Section 155 compromise? And in a very worst case situation, is it a liquidation? It's very seldom that we make the decision to liquidate at the beginning, and there's by no means any incentive for us to liquidate the company at any stage of the game, and our real aim is to get the company back on its feet and to trade as a solvent going concern again. So liquidation is something that we have very, very seldom decided on right up front. Section 155 compromise is basically an alternative to business rescue, and sometimes it's a lot cheaper than business rescue, and sometimes it's a lot quicker than business rescue. It can happen in a much quicker fashion. So also headed up by a turnaround practitioner. He would basically put together a plan whereby each creditor in each class receives a compromise or a haircut to a certain extent. Once he's put together his plan, he then calls the creditors together, and he has a meeting, as he would in a business rescue process, and he presents the plan to the creditors, and each class of creditors then has to vote to decide whether or not to approve the plan. And sometimes a Section 155 compromise can affect only one class of creditors, and in that case, only that class of creditors would be required to approve it. If it affects all classes of creditors, then all classes of creditors would be required to vote. As in a business rescue, the vote is determined, the vote that is required to pass it is a 75% vote of the creditors in each class who vote, be it by person or by proxy. So you'd have, for example, a secured creditors class, and then the preferent creditors class, and then the concurrent creditors class. And to approve the compromise, well, the compromise would state that secured creditors are going to take a 10% haircut, preferent creditors are going to take a 20% haircut, and concurrent creditors are going to take a 50% haircut. Each class would be required to vote in favor of approving that plan. So 75% vote would be required by value of the people who vote. Once it is voted and approved, if it's not approved, then the business rescue practitioner or the turnaround practitioner can carry on negotiating and hopefully get to a result at the end of the day. Once it is agreed, then the practitioner takes the compromise to court and has it ratified by the court, in other words, made an order of the court. And then it is immediately effective. The creditors' balances are compromised from that date, and that's normally where a Section 155 compromise ends. It has been done where the company carries on employing the services of the practitioner once the compromise has been approved, in other words, to assist with the turnaround of the company. one of the key differences between the Section 155 compromise and the business rescue is that the compromise doesn't enjoy the protection, or the steel blanket, as we like to call it, the protection, the moratorium during the time that it's being negotiated. It's only once it's been made an order of court that the new creditors' balances are effective, and the company can carry on trading as a going concern. But it does not enjoy the protection that business rescue offers. So Section 155 compromise typically works where you have fairly friendly creditors you can negotiate with, creditors who want to make a plan. If you have hostile or aggressive creditors, it's often better to have the protection of business rescue, so that you can put together the plan and then implement the plan without having applications to have assets attached, without having judgments against the company, without having liquidation applications against the company. I think that more or less covers it, Maurice.
Yeah, thanks, Ian. That provision I was referring to, have a look at this. So within any period of 10 years after the effective date, the person has been a director of more than one company or a managing member of more than one closed corporation, irrespective of whether concurrently, sequentially, or unrelated times. And during the time the person was a director of each company, the manager of each code, two or more of those companies each failed to fully pay all of their creditors and meet their obligations. So you fall to become declared delinquent as a director unless it's in terms of a business rescue plan or a compromise in terms of 155. So that's quite important. But I make an observation here, and that is that the wording here is may. Okay, a court may, as opposed to must. If you go above here, you'll see the circumstances where the court must declare a director delinquent. There, a court must make an order declaring a person delinquent, so there is may. But the fact of the matter is that's another reason to put a company in business rescue or do a 155, because then you actually protect yourself, you shield yourself from a potential delinquency in these circumstances. But having said that, I have no doubt that a court is not going to be declaring any director delinquent if the circumstances are COVID-19, without a doubt. I just want to jump into how does one deal with employees. Ian and Peter have touched on employees, but it's a very, very important aspect of business rescue. What I'm about to tell you relates to pre-business rescue and post. And that is because employees are subject to the same legislation as they enjoyed prior to, the same rights that they enjoyed prior to the business rescue. So you still have to negotiate with the employees, you still have to reach agreement with them. And if there are going to be any redundancies, you have to follow Section 189 of the Labour Relations Act. And the way Section 189 works is it has a dual purpose. The one purpose is a redundancy. If you consult, you're obliged to provide a notice, a written notice, and you need to meaningfully engage with the staff with a view to reaching consensus on certain aspects set out in Section 189. Those aspects are issues such as the timing of the dismissals, the reasons for the dismissals, the proposed alternatives that were considered by the employer. So it's quite formalistic in the sense that the notice has to be given. The notice doesn't have to be in legal wording, it doesn't have to be formal in that sense, but you do have to comply in giving the notice with the section. And the section does say that you have to record certain aspects, such as even how many employees have been retrenched by the company within the preceding 12 months. Now that's when it comes to redundancy. Then there's what a lot of companies are doing, which is to reduce staff salaries. And what we've encountered is that companies are, in essence, standing up, telling their staff, we cannot afford to pay salaries, and they are simply slashing the bill by, let's say, 25% and presenting the staff with a fait accompli. Now, you cannot do that. If you want to unilaterally vary a staff member's employment terms, in other words, not terminate but vary, you still have to go through the Section 189 process. You still have to consult with their employees, and the variation, the reduction in salary, the remission in salary, that is presented as an alternative to retrenchment. If, however, the employee does not agree and is not happy with that, the company then is obliged to pay that employee a severance package and to terminate the staff member's employment. So it's tricky because you have the severance pay. I think it was Ian or Peter mentioned earlier that what they have done previous years, enter into agreements with the staff to pay the severance pay off. But it's one hell of a burden because it's a double-edged sword. You're trying to cut costs, but in doing so, you're actually incurring a liability that you cannot afford. So I want to turn to Ian now, because Ian's methodology as a business rescue practitioner is to go into a business and to determine what fixed expenses are necessary and what fixed expenses can somehow be changed by agreement. Just take us further there. What is your modus operandi, Ian?
Certainly, Maurice. And let me just say that there was an interesting article that came out on the weekend about SAA. And obviously the unions are up in arms about the SAA business rescue practitioners and threatening to have them removed and so on. And one of the interesting points that was made was that the Section 189 retrenchments that are going to happen, the company will not actually have enough money to pay out the severance pay. So that's exactly what we were talking about now, and what we've come across in practice before, where companies just doesn't have money and can't pay off the severance pay packages, and basically has to rely on future operations or future post-commencement finances or future asset sales in order to pay the severance packages. So very sadly, that is unfortunately what SAA seems to be faced with at the moment, on top of all its other troubles. So Maurice, yes, as far as fixed costs go, we've realized, and we basically envisaging a paradigm shift both in our local economy and across the world towards moving away from fixed cost structures or fixed cost business models more towards variable cost business models. And it's simply because we won't have a choice. People won't have a choice to do so. The reason for this is that, for example, take a landlord. Now take a company, take the Spur Group, for example. Now we've been preaching since the beginning of, since 2 weeks before lockdown, that companies would not be able to afford fixed rentals. They would need to actually consider moving to variable cost models as a result of the COVID-19 crisis. Now, take Spur, for example. They came out last week and basically said that they certainly won't be able to, they won't be able to pay rental once the restaurants open again, and they'd only be able to pay a minimum turnover-based rental. Now, right from the start, we've been saying, have to move companies onto a variable model. Now, rental is one of those things that is typically your biggest fixed cost, rental and staff, especially in the hospitality industry, for example, restaurants, who are the first ones to be bearing the brunt of the COVID-19 pain. And so what we've been doing is we've been sitting down with landlords, and luckily, fortunately, the property owner incentives that have come out from SAPOA and SA REIT and the South African Council of Shopping Centres have been very progressive and have been very considerate to tenants. And what we've basically been saying to landlords is that let us open again after lockdown is finished, and let us trade, and let us pay you a percentage of turnover as the rental, because that's the only way that the landlord or that the tenant is going to be able to afford any form of rental whatsoever. And it's the only way the landlord's going to receive any form of income. Similarly, as Maurice stated earlier, as far as employees go, we've been negotiating with staff, and they've been very receptive to receiving a reduced salary package, in many cases a vastly reduced salary package, just to be able to still have a job at the end of the day. So this is all seeing a vast movement away from fixed cost structures to variable cost structures. And what I say What I mean when I say variable cost structures is a cost structure that is linked as much as possible to the turnover of a company.
Oh, thanks for that, Ian.
Sure.
You guys will have seen by now that restaurants now will be permitted to deliver. I think it was only on Thursday I was lecturing or presenting saying that that was not the case. So it just shows how rapidly these documents change. But now I just want your views, Peter, in relation to that. I mean, you guys have been involved now presently with quite a few restaurants. What are your views? Will these businesses be salvaged? What do you make of the fact that the estimate now is they reckon that 70 to 80,000 jobs will be saved as a result of this, but will they? I mean, will these businesses be able to survive?
Maurice, yeah, look, it's a tricky one because one's still got to look at it on a case-by-case basis. And, you know, it's one thing if your restaurant is a limited number of covers and your takeaways are already a significant part of your turnover. You know, we did have somebody on one of the webinars earlier last week where the restaurant owner said, you know, only 3% of his turnover came from takeaways. So that's a big, and I think he said he had 200 covers. Now that's a huge restaurant. To turn that into a profitable business over a medium term even, let alone a short term, I would say is almost impossible. So that's the one thing that one's got to consider is how flexible is the restaurant to convert to takeaways. The second important thing here is that a restaurateur making that decision, there's a number of other people involved. Obviously, the landlord is trying to extend or retain his lease, so there's got to be a negotiation with the landlord, very much on what Ian's just been saying, because turnover by default is going to be lower, unless you are, as I said earlier, interesting enough, like a Steers, where a lot of their business, or majority of their business, is takeaways. So case by case basis, see what the cash flow implication is going to be. Bear in mind, you can probably operate, I'm advising a restaurant at the moment, it's a chain of 4 restaurants, all individually named, and the restaurateur is quite adamant that he can operate one of the facilities with a skeleton of staff, and you know, get everybody to become sort of jack of all trades. This is a guy who's a fairly well-known chef in this town, and he said he's quite happy to start working in the kitchen, doing preparation, etc. So, you know, take on additional duties to try and get the takeaways going. However, one's still got to look at that business model. Does it work on the reduced turnover with a skeleton staff? It may well do, but it's not going to be the sort of size of a business that is going to employ all the staff that were in the establishment prior to this crisis. So I don't agree that, you know, if you just look at how many people in the restaurant trade, employees, you can't just say, well, they're in the trade, therefore they're going to continue in gainful employment. It's not going to be the case.
So now we have a scenario where not all the employees are going to keep their jobs. I'm going to move over to Dean to tell us what they can do, what the businesses can do to assist. Dean?
Thanks, Maurice. So yes, there are a number of fund relief packages and measures that are available, and we'll come to the TERS one specifically in relation to Peter's. But I just want to urge all the listeners to have a look at our COBRA.org.za website. We spent hours and hours, and as part of one of the bigger pro bono initiatives is creating a single place for all these resources. And if you go to the website and you scroll down to the bottom, there's a link there that says Help Portal and Knowledge Base. And just to give you a bit of an idea of all the initiatives that we've summarized there, together with Business IQ, there's about 37 initiatives. And just the highlighting ones are bank initiatives. There's 6 major offerings. Government initiatives, there's 18 different offerings. Solidarity initiatives, 3. Business is 2. And there's insurance offerings as well. And it even goes down to telecoms initiatives from MTN and Vodacom. For example, you can go onto the UIF website free of charge. You actually don't need data. And that was one of the Vodacom initiatives. but to go back to the TERS one, which is one of the ones we get a lot of questions about, and the feedback is that a lot of the applications are rejected. We have to see that email first to advise why it was rejected and how we can assist. But I mean, just as a note, the documents that are required to make use of the TERS, and for those of you in the audience who don't quite know what the TERS initiative is, it stands for Temporary Employer and Employee Relief Benefit. So what this is it's a fund that's been made available for employees in businesses where the employer has been paying UIF, is registered for UIF prior to the COVID lockdown and crisis. And there's documents that are required at an initial point, and those are obviously a letter of authority. An MOA will be required, which is a memorandum of agreement to be concluded between that company and the UIF. And there's a couple of a template that needs to be filled in that has various information required, evidence of payroll for at least 3 months of the employees' salaries that you will be applying on behalf of, and confirmation of bank account details. So what this initiative allows you to do is claim a percentage of each employee's salary, from 38% being the maximum, and that's linked to a 17,000 Rand a month maximum salary. So if you look at those numbers, the maximum anyone could apply for on behalf of an employee is about 6,700 Rand. That's if they reach the top tier. Again, that's the 17,000 Rand. And obviously there's a sliding scale down. A couple of questions we get asked about tiers are whether it applies to all or some employees. And that comes down to what Peter was saying. And that's really that, are the employees able to work? Are they able to partially work? Those are the employees that are affected. And those are the ones that you should make application on behalf of. The other important aspect of it is whether you were, say, in default of your UIF payments, whether you were able to regularize this. And, you know, we haven't been able to get a hard and fast answer on it, but the point of the scheme is not to make employees suffer. So there's sort of logic that dictates that we've seen before UIF have been amenable to entering into AODs to bring up the UIF payments, and hopefully these will still allow the employees who are affected to make use of that fund. And I was just looking at this morning on that offering that we have on that knowledge base, and I see there's quite a new one, which is manufacturing fabric and cloth face masks. That's quite a new offering, and I think everyone I've seen in the news, everyone is now jumping on this bandwagon, and there's some very good information there. Just to highlight, the call out is meant to target only South African small businesses and cooperatives, and you need your SIPC documentation, FICA documentation, bank account, and business profile. And I think that's quite an important thing, Maurice, to understand on all these funds, is that it seems like these funds are just there to give out money. But in reality, a lot of them are actually loans, and a lot of, especially the bank initiatives, are going to be backed by some type of a surety, which we go back to, we mentioned surety. So there are lots of technical aspects on it, and if anyone needs more help, you're more than welcome to pop us an email at info@cobra.org.za. And another thing that we don't mention often enough, but on this COBRA website, in the bottom right, there's a button, it's a green button that says request assistance. And it's so well popularized that you can search anything. It's like a little Google. You can search any keyword and it'll bring you to that article that's on that database, which I find is phenomenal. And it's the quickest source of getting information on these things.
Brilliant. Yeah, so before I jump into COBRA, I'm going to ask Adam just to jump in and tell us about COBRA's initiatives insofar as big business is concerned. I'll deal with smaller businesses and how we assist there. But before we get there, if we can just ask Ian, what happens if the business rescue plan fails?
Maurice?
But before I get there, it fails in one or two ways. Either it's not voted upon, or it's voted upon, it's approved, and it just doesn't work. It was a done business plan. It just didn't, you weren't able to pull it off.
Sure. Okay, so let me first quickly address the first question. If a business rescue plan is not voted for by the creditors, then the business rescue practitioner will normally negotiate with the creditors, and he'll ask them if he can reword the business rescue plan or change the business rescue plan in a way that will allow them to vote in its favor. If the creditors agree and a compromise is reached, then the business rescue plan is amended and the creditors vote for it. I always said that the whole business rescue process and the part of the process of putting together the plan and presenting it and voting, it's really one big formalized negotiation process. So if at the end of the day the business rescue practitioner cannot put together a business rescue plan that the creditors agree to vote in favor of, then it's incumbent upon him to liquidate the company. He has to then put the company into liquidation. This very seldom happens because normally we do find a compromise with the creditors and we find a middle ground, and we prepare the business rescue plan on that basis. It gets voted in and then implemented. Second part of your question: what happens if 6 months down the line or 12 months down the line the business rescue plan has failed? In other words, it hasn't been carried out as it was intended, and the financial projections might have shown that the creditors start getting repaid after 6 months, and by month 12 the creditors' payments haven't been restarted yet. So normally, under pressure from creditors, the business rescue practitioner would look at the plan and have to say, look, this plan isn't working out. How do we go about, what do we need to do to make it work? And what he can then do is he can revise the plan, revise the financial forecasts, and then get creditors to vote on it again. Now, let me just say, it's not always because it was a dumb plan from the outset. Very often, every time we're putting together financial projections, be it in a business rescue, be it in a business model, a financial projection is really, it's just the practitioner or the preparer's best estimate of how that plan is going to play itself out. Now, as business rescue practitioners, we only have 25 days in which to prepare a plan. In other words, to understand the ins and outs of the business, the causes of distress, how it can be fixed, committed to paper, and then presented to creditors. So very short amount of time, and it very, very often happens. 99% of the time, the plan doesn't roll out exactly as it was put forward. So then we can go back to the creditors' vote, the same as the Section 152 vote that we had right at the beginning, and we can allow them to vote on the plan again. If they then vote on the amended plan and approve it, then we roll out the amended plan as we put it forward to the creditors. If they don't want to approve it and they feel that it's just this is not working, let's just end it, then it's our responsibility to then liquidate the company. That's pretty much it, Maurice.
Yeah, no, that's great. Thanks for that. So just on the score, you were making mention of a liquidation, and I think it's important for us to explain COBRA, because COBRA will cover the costs of a liquidation. Those costs generally are in the region of between 30 to 50,000 rands. You have to pay attorneys to do it because it's a high court application, and those are covered. What else is covered by COBRA? COBRA covers consultations, Zoom consultations. If you need to meet with an attorney, a specialist in a field, that's covered. And we've put together a panel of dozens of experts and professionals who are prepared to assist on the basis that you will not have to pay if their fees come between a successful business rescue and a liquidation. So the idea is to have a team of, just to give you an idea, there are in excess of 1,000 professionals who are committed to COBRA. So in excess of 1,000 individuals who can help out on the basis that if you need pro bono, it's there for you. For the small businesses, we've dealt with quite a bit today as to how they dealt with, but we're finding bigger and bigger and bigger businesses, and we've seen the likes of EdCon and SAA financially distressed. And we've been able to partner with IQ. IQ Business is one of the founding partners, together with Schindler's Attorneys and Engaged. IQ have come in, they've been around for 22 years, and they're top of their game when it comes to assisting businesses. This is what they do. And they did not hesitate to form COBRA. And they're here today, and we're privileged enough to have their CEO, Adam Craker. He's with us today, and he'll tell us a bit more about IQ. Adam?
Good morning, Maurice, and to all participants on this somber day in Johannesburg. Pretty grey and miserable out there, but I'm not here to give you a weather forecast. I thought what I would do is just share with you the latest MIS that's coming through the COBRA War Room. Hopefully you can see on the screen the COBRA War Room data insights. I got very excited about this on Friday, because we've now had a month of participation coming through the COBRA War Room. And I think it's very telling to start to see some of the data points. As always, the first run of the data is somewhat incomplete in some areas, and we'll improve it as we go forward. What you can see on the screen here is the breakdown of 95 cases that are cutting across pretty much all industry sectors, but with a predominance in the retail, hospitality, business services, manufacturing, construction, and tourism sectors. We're working on breaking down the other category here to get more detail into the business types that are coming through and making requests. You can see the makeup of private companies, closed corporations, and sole proprietors in the mix. What starts to get interesting is when we break down the size of those businesses. By far, the 2/3 majority are sole proprietors or very small enterprises. That's the initial wave that are coming through. But we've started to see some pretty large organizations with 500 plus employees that are also requesting support and assistance and accessing the subject matter experts and knowledge base, and a steady mix of medium-sized companies coming through. The other angle, which I found particularly interesting, is to look at the profile of banks that are represented. So these companies that are rapidly moving into distress, doing business with the top 5 banks in South Africa. FNB really featuring strongly, nearly 50% of the businesses in relationship with FNB, with Standard Bank, following close after ABSA and Nedbank and Capitec. Then the makeup of the employee mix across sectors, with retail again featuring very, very strongly, business services, hospitality, no surprises. Ian was saying earlier on that there are certain sectors that are very rapidly moving into distress because of their circumstances, because of the pressure point, because of the lockdown that is preventing them from doing business. We expect to see all sectors being represented over time, and that the growth as the economic crisis really takes a hit in many of these sectors. What was also interesting was to look here. What I found interesting was when I saw that makeup, 50% of the businesses represented with FNB, but by a large part, these are professional or small business enterprises with employees of on the scale of 1 to 10 employees. So FNB overrepresented in that space. Standard Bank with the larger profile, and Nedbank and Standard Bank with some of the larger organisations that are coming through. And then the final perspective that I'll share today is Dean was talking earlier on about the source of business leaders that are coming through, predominantly through clicking that widget on the website. So going through to the cobra.org.za website and requesting assistance, over 50% coming through that method, 30% from email and then access through our knowledge base and direct access coming through. What this final graph shows you here in the corner of the screen was also quite interesting. This is the origination of those requests for support, and this shows on a week-by-week basis. We've been operating since the start of April. Thursday is the peak day every week of the month. So this seems to be the realization point as businesses are coming through, and Thursday is the day of reckoning during the week, and we see more cases than any other time during the week. Maurice, I'm very conscious of time at this point. I'll hand back to you and ask if there's anything else.
No, I think that's it. I think we can wrap up. You did mention that you did refer to sole proprietors. So I'll conclude just by mentioning that sole proprietors, partnerships, and trusts are not subject to the business rescue legislation that COBRA is. So you can still come into the COBRA environment, and we'll still assist you in rescuing your business. And truly, finally, I must mention that what COBRA has also become is a marketplace. And what's nice about entering the COBRA environment is not only will we negotiate with your creditors to strike up relationships and get those creditors into the environment, but we've also found that services are being offered within the marketplace. So everybody's invited to join if we can help. It would only be our honor and privilege. So please reach out, info@cobra.org.za or www.cobra.org.za for the knowledge base and further information. Thank you to my panelists. Until tomorrow, thank you very much. Bye-bye.